Henry James Rubb, 21 CR 050378.
Good morning, Your Honor. Richard Schoenfeld and David Chesnoff appearing on behalf of Henry Ruggs. Request his presence be waived.
Morning.
Morning, Your Honor. Morning, Your Honor. Peter Jansen on behalf of Kiara Washington.
So I didn't see Mr. Chris Jansen. I didn't see your motion. So
Did I filed it, served it, and he served it?
not in the file. So tell me about it.
Pretty simple. I joined Mr. Schoenfeld and Chesnoff's motion.
Okay.
And I joined the argument they made yesterday as well. Then, Your Honor, the only thing in the motion filed by the state and the order entered by the court getting my client's record was a citation to the CFRs. No citation to the Nevada statute. No citation to the exception that they put in their opposition saying, hey, we're entitled to go get documents under the exception, under the patient litigant exception. They actually don't even cite Nevada law. So under the order that was signed, you should just completely rescind the order, say Nevada law applies. Nevada law under Chapter 49 allows my client to assert a privilege over her medical records and communications with her doctor. The only possible exception is the written records. And Your Honor, frankly,
How are they going to authenticate the blood test results?
blood test has nothing to do with my client. My client's a passenger in the car. My client has a claim.
My ruling yesterday was the blood test results would be released.
Yes, sir.
In addition to the authentication of the medical records and nothing to do with conversations or treatment as to any patient-doctor relationship.
Understood, Your Honor. And I would point out to the court that my client's blood alcohol is not at issue. She's a passenger in the car driven by Mr. Schoenfeld and Chesnoff's client. So what they're looking for my client is her medical records, and what they want, and they tell you this in their opposition to my motion, is they want her communications with her doctors, her verbal communications. And they cite the exception that says they're not entitled to it. The exception says they're entitled to the documents, if that. And frankly, Judge, that's for the litigant-patient exception. My client's not a litigant. She's not part of this case. She's a victim. They're only entitled to it, and they cite the Mitchell case for you. Let me tell you about the Mitchell case.
So hold on. So it's my understanding you guys are going to draft an order, you're going to have a conversation with the state and try to propose some type of order that could be executed by the court, and obviously we're not there yet, correct?
Looks like Mr. Chesnoff's holding something, Judge. I'm not sure.
We sent this over to the DA last night. Mr. Baumann was kind enough to say that we could present it to you, Your Honor, for approval.
Mr. Baumann, did you review it?
No, I did not. I was of the belief that the court staff was ignoring the order.
Okay. Need to look at it.
Fine.
Review it.
There's two copies there. Your Honor.
Okay.
Your Honor, I'd only ask the court to take a look at the Mitchell case, which is cited by the state.
Mitchell?
Mitchell, standing for the proposition that they're entitled to all the communications between my client. They're not. Mitchell's a case where...
Chris Jansen, I'm already there. We're good.
Going up.
I don't think they're entitled to my client's medical records. Mitchell's a case where a doctor gets sued by a patient who's got a drug problem, the doctor does. And the Supreme Court, when the doctor asserts his privilege to not have his physician, psychologist, protected stuff, he doesn't want to give it over to the patient who sued him for malpractice. It's my case.
You're in agreement, though, that your client's blood test results can be released to the state. Is that correct?
My client's blood test results are not at issue, Your Honor. I'm not in agreement.
Okay.
Your Honor, we are not seeking anything resembling blood test results from Mr. Chris Jansen.
What are you seeking for Mr. Chris Jansen's
Mr.
client?
Chris Jansen's client is an alleged victim in this case. We're seeking medical records that establish the injury that he suffered in the crash.
What relevance is that?
We have to establish substantial bodily harm. It's an element of the crime being charged.
Mr. Chris
It's an
Jansen?
element at issue in the case.
No argument it's an element of the crime. No argument my client is a alleged or putative victim. The problem is the order that was signed by the court only references the CFR, which doesn't allow them to go get the documents. Doesn't allow communications. And what they asked for, what was signed in the order, is communications. They want a person to come to court and say, Kara Washington told us the following about her.
We're not allowing that. We're already there. We've talked about that 3 times now.
Understood, Judge. So my position is under the litigant privilege. My client is not a litigant. That's the exception they cited. They're not entitled to her records, period. If you're going to, and they're certainly, as you said, not entitled to communications, but if you're going to give them records, it's simply that. That's my position.
Which is where we were at, Your Honor. We agree, and we also want to be clear that alleged victim is important for us to put on the record, Your Honor.
Obviously. So let me review this. Ms. Schofield, why don't you stop by later? Like maybe an hour, hour and a half.
That's fine.
Let me get through it.
Can the state make an argument on Mr.
Go ahead.
It's the state's position that under 49.245, there is no privilege to object to the state obtaining medical records as to written or medical hospital records relative to an issue of the condition of the patient in any proceeding in which the condition is an element of the claim or defense. That's precisely the issue we have. It's an element of the claim made by the state is that she suffered substantial bodily harm. And you follow the correct procedures and obtain a quarter.
Ms. Christiansen, final argument.
Judge, I point you to the case they want to rely on, which was my case. I represented the doctor. Mitchell versus 8th Judicial District Court, 131 Nevada Advanced Opinion 21, stands for the proposition that if in a litigant privilege, a litigant, not a victim, not a bystander, a litigant, like Dr. Mitchell was in that case, asserts a privilege, then a district court, before it can even give the subpoenaing party the documents, has to do an in-camera review to make a determination that the documents they want meet an element for a litigant. My client's not the litigant. So I'll submit it on that, Your Honor.
Okay. All right, stop. We're done. We're done.
Your Honor, we also wanted to address the preliminary hearing date. It's scheduled for next week.
Right.
Dialogue
Well,
with the state.
I was thinking about that, and do we need to continue that? I mean, there's obviously no prejudice to your client since he's out of custody.
Your Honor, we do need to continue it in terms of receiving discovery. We've received some discovery today, but
Okay.
it's the first substantive discovery we've received. So as a result of that, we do need to continue it. We've discussed it with Mr. Baumann.
Let me interject. Is there a certain discovery that you're looking for that's not been provided?
I don't know yet, Your Honor. We did send a comprehensive request for discovery. We just received this today. I will note that the court told us we had authority under the law to issue a subpoena to the Clark County Fire Department, so we did issue and serve that subpoena. The return was yesterday. We did not receive any documents.
Okay.
I will reach out to try to find out who the counsel is and see if they're going to produce that. If not, we'll have to bring that before the court.
Do you want to set a status check date as to the discovery in addition to the prelim?
That would be great.
So maybe, I'm thinking maybe 2 weeks for status discovery and maybe prelim in 30 days?
I think prelim ordinary course, Your Honor, maybe 30 days for discovery.
Let me tell you why, Your Honor. When Mr. Baumann was...
It's okay. I mean, it's your client. I mean, it's their right.
Fine.
So proposed ordinary course date would be?
March 10 at 9:30 in Department 8.
Ms. Schofield, do you want to go that far?
Yeah, that's fine, Your Honor.
Madam Clerk, is that a Thursday?
That is a Thursday.
Thank you.
And as to the status, as to discovery, you want to maybe, Ms. Schofield, now I'm thinking it's so far up, maybe we want to do 30 days.
That'd be great, Your Honor.
30 days would be?
January 6th at 8 a.m. in Department 8.
January 6th. Is that what it was?
Yes.
Thank you. And don't forget, that'll be Department 8 Judge Zimmerman.
Thank you, Your Honor. And in the event that the fire department is not going to be cooperative in terms of the subpoena, we will bring that before the court.
And in order to show cause, I would think.
That's what it would
And
be.
Your Honor, I've spoken with civil counsel to the fire department and they intend to cooperate fully.
Thank you.